Hi, folks. Welcome to C Files. Thank you for joining us. Don't forget to like and subscribe. Hit that bell notification if you want notifications of these videos. Share with your friends if you think these are videos that are beneficial and worth uh, content worth them viewing. So I got a copy of the Constitution here, and let me open to where I need to go. I'm passing up all of the articles for right now. I'm going to do a series on the Constitution. We're going to talk a little bit about it. I've got thick books back there that discuss the Constitution and all of its meaning. But right now, I'm going to give some basics, and we're going to begin with the First Amendment. I'm going to continue my series on Scripture, but also I think this is important as well. Because we often say that we know our rights. And when I was in law enforcement for 30 years, one of the things I had to study was people's rights. And I had to study especially the Fourth Amendment. And we'll talk about the Fourth Amendment in a different video and case law involving the Fourth Amendment. So you can understand when it comes to search and seizure where the limitations are for law enforcement officers. That's important for you to understand. And understand where the limitations are on you when dealing with law enforcement officers. But we will do that when we get to the Fourth Amendment. Right now, we're going to be looking at the First Amendment and freedom of speech. The First Amendment says the following. By the way, this was ratified. The Constitution was ratified December 15th, 1791, or the first 10 amendments. I'm sorry, the first 10 amendments to the Constitution were ratified on December 15th, 1791. Amendment 1 says this: Congress shall make no law respecting an establishment of religion. In other words, Congress cannot make a state religion, even though the government has a state religion. It's called secular humanism, which we need to really push back on the government for pushing that state religion on our kids in the public schools, but that's another matter. We'll talk about that at some point. Anyway, Congress should make no law respecting an establishment of religion or prohibiting the free exercise thereof. When the government shut down churches during the last pandemic, that was, in my humble opinion, prohibiting the free exercise of religion and a violation of the Constitution. But the courts there'll have to be a case for actually there was a case in California where John MacArthur's church, I can't remember the name of his church. Anyway, his church in Los Angeles. I've been to his church, actually. He filed a case against the state of California for requiring him to be shut down during the last pandemic. And he won that case. The California Supreme Court, believe it or not, the California Supreme Court actually said that the state of California had violated John MacArthur in his church, in the church there. Why can't I think of the name of the church? I don't know. Anyway, that they had violated their right to free exercise of religion. So that's an interesting case. We'll talk about that at some point. Or abridging the freedom of speech. Now, this is where we're going to land today, abridging the freedom of speech, and I'll tell you why I came on that in a moment. Or of the press, or the right of the people peacefully to assemble and to petition the government for a redress of grievances. So here's the different parts of the First Amendment. Excuse my throat. The government cannot establish a religion and force it on the rest of us. The government cannot prohibit the free exercise of a religion among the people. The government cannot abridge the freedom of speech. The government cannot abridge the freedom of the press. The government cannot abridge the right of the people to peaceably assemble and petition the government for redress of grievances. So there's your different parts. Let's talk about free speech. The reason I landed on this one is because there was a couple of cases recently at the city council level in small town USA. I don't remember exactly where the location of the case, but where a couple of cases where people were arrested during speaking to the city council, expressing their opinion in their 2 minutes, 3 minutes, whatever amount of time they were allowed to speak before the council. And they were arrested because they didn't stop speaking when the mayor said, "Shut up and stop speaking." And this is the same town and the same mayor. Now, granted, the speakers were making disparaging remarks against the mayor, and they were challenging his character, if you will, making personal insults against the mayor and making accusations against his character. We'll put it that way. So the mayor didn't like that, so he had them arrested and taken out because they refused to stop. They were still within their time frame. They were saying, "This is my free speech. You're restricting my free speech." The mayor saying, "Nope, you can't attack the council members. You can't attack the mayor personally. You're out." So I thought, I wonder if that's a violation of freedom of speech. So I did some research and I found 17 free speech cases that I think everyone needs to be aware of. So we'll go through them quickly. Case number 1 is Gitlow versus New York. This is 1925. And this case says that the government, state or federal government, and of course a city council would come under the auspices of the state government, cannot violate the free speech rights of a citizen, right? Benjamin Gitlow, a socialist, was accused of writing a seditious manifesto. The New York state law he violated was in violation of the First Amendment. So they arrested him because he wrote a seditious manifesto attacking people and pushing socialism, okay? So that was a violation of his free speech. Now, that's a case I believe that could come into play if the people who were arrested in that city council meeting decided to file a lawsuit against the city council for violation of their free speech. This case very well could come into play in a case of that nature. The next case is Stromberg versus California, 1931. Free speech protects more than words, according to this case. It was legal for camp counselor Yetta Stromberg to fly a Communist Party flag at a summer camp. And so flying a flag is an expression of speech, and it's free speech. West Virginia Board of Education versus Barnett is the third case, 1943. A West Virginia law requiring students to pledge the flag violated free speech rights of Jehovah's Witnesses who refused to participate for religious reasons. So if someone for religious reasons does not want to stand for the national anthem or pledge allegiance to the flag, this case in 1943, West Virginia Board of Education versus Barnett says that they're not required to to either pledge allegiance or stand for the national anthem. Talley versus California, 1960. First Amendment freedom of speech includes anonymous speech. The court ruled in favor of civil rights activists who wanted to distribute an anonymous pamphlet about discrimination. This was an ACLU case where the state wanted the ACLU to uh, reveal the names and addresses and so forth of its members. And the ACLU says, no, we're not going to do that. Can you imagine the atmosphere in 1960 when it came to something like that? And the Supreme Court said, no, you can't do that. I'm sorry. And you know, of course, for the purpose of arresting someone for this anonymously distributing pamphlets that you don't agree with, you can't do that. All right. United States versus O'Brien, 1968. Freedom of speech includes expression with the following exceptions. 1. The law or regulation must be within the government's constitutional power. In other words, if they're going to restrict free speech, it has to be within the constitutional boundaries, right, that have been determined by case law by the Supreme Court. Number 2, the law or regulation must further an important or substantial government interest, a good reason related to the government's responsibility. And so that's, the government can't just say, I don't like that, therefore I'm going to restrict it. They have to show that it has an effect upon the government carrying out its responsibility to the people, and even that is very, very restrictive. Number 3, the law or regulation must not be able to must mistype that. The law or regulation must not be related to, the suppression of free expression. It cannot restrict the expression based on the message it is trying to convey. In other words, if the state's going to make a law concerning freedom of speech, it has to, it can't be restrictive beyond what the court says is allowed. The impact, this is number 4, the impact of the law or regulation must be no greater than necessary to achieve the goal. So these are the boundaries that are, this is a very, very high standard set in United States versus O'Brien in 1968. Now, in this case, the government did not meet these 4 criteria when it punished Paul O'Brien for burning his draft card in front of a Boston courthouse. For those of you who were not alive back then, the government used to give out draft cards when they had a draft, and a draft being that they would draft you into the military. The Vietnam War was on during that time, so they were drafting people to come into usually the Army and go to Vietnam. And a number of students at that time were protesting the war, and they were burning their draft cards. Well, this gentleman was arrested for burning his draft card. Now, this is an interesting case because there is something that the court had to say concerning that. That's interesting here. The court disagreed. Let me go back. O'Brien argued the act was political speech. So O'Brien was saying this is political speech. You can't restrict it. But the court actually disagreed with that particular argument. 8-1, they disagreed with it. However, they said that the government was not punishing O'Brien for opposing the draft. It was protecting its ability to administer the draft because draft cards were the only means of identifying an individual's draft status. That's an interesting little sideline on that particular case. So this kind of goes back to where it says the part on number 2 where it says the law or regulation must further an important or substantial government interest, a good reason related to the government's responsibility. In other words, the government's responsibility at the time was to send out the draft cards and use those draft cards as a means of identifying individuals for draft status. burning the draft card hindered that particular responsibility of government. So the court decided that, said, no, you can't make that argument, because that was within the boundaries of the government interest. So you can see how these cases become quite complicated. But the government did say, in favor of O'Brien, that there was an aspect to where the government was very, very restricted in what it could do to O'Brien when it comes to the burning of that draft card. So, but O'Brien really didn't prevail well in that case. All right, now we have the next case, which is Brandenburg versus Ohio. This is 1, 2, 3, 4, 5. This is case number 6. This was in 1969. The court raised the bar for when inflammatory speech can be limited, setting the current very high standards, a very high standard now. It said the speech must, quote, incite imminent lawless action, end quote, which means that the speech must affect an immediate danger to a person before it can be restricted. If someone says they should all be arrested and executed, everybody believes this particular thing should be arrested and executed, that's actually free speech. But if you're going down the street and you point to someone in particular and you say, everybody get that guy, he believes this and he needs to be executed, go get him, that is a violation. That doesn't fall within the realm of free speech under this case. So you see the difference. The court raised the bar for when inflammatory speech can be limited, setting the current very high standard. It said the speech must incite imminent lawless action, and so that's what that means. It is specific intent decision. Now, specific intent is they had to have the specific intent to bring harm to that individual by means of their speech for it to be illegal. The specific intent of the speech must be to provoke or directly cause crime or violence right here and right now. So that's the Brandenburg versus Ohio case out of 1969. And then there's the Tinker versus Des Moines Independent Community School District in 1969. This case dealt with public schools students' right to freedom of speech. Public school students have First Amendment free speech rights at school. The 3 students in this case, John Tinker, Mary Beth Tinker, and Christopher Eckerd, were suspended from school for wearing black armbands to protest the Vietnam War. And back then they would wear these black armbands for that protest. And that was tied in with the Black Panther Party, as I recall. Anyway, the court ruled that schools can only restrict limited students' expression if they can be relatively sure that it will truly and substantially disrupt school or harm others' rights. If someone is, for example, preaching on a campus, like in a community college campus, people can go on campuses more freely than they can a high school. And there are cases where people go on and they preach sermons and things like that, trying to evangelize people. That is okay, so long as they are not disturbing or disrupting a class that is in session with their loud speech. If that is happening, now the officers have a right to come in and say, sir, we need you to move to an area where you're not going to disrupt this class. I can see people getting upset about that, thinking that the officers are just harassing them and trying to limit their free speech. No, the Supreme Court has said you can't do that. You can't disrupt someone teaching in a class at a college in that case. So it's important to know that. Cohen versus California in 1971 is the next case. Profanity is protected as free speech. Yeah. Paul Robert Cohen was convicted for breach of the peace. Isn't that interesting how some of these laws are written? Breach of the peace. Very wide open, generic, not very specific when it comes to that law. I mean, what does that mean, breach of the peace? That's very wide. Anyway, because he wore a jacket with a curse word on it to the court. So he went into court with a jacket that had a cuss word on it, and it was offensive to the judge, I guess. The Supreme Court reversed the conviction 5-4. However, the majority said Cohen's speech didn't meet the criteria for unprotected categories of speech, which is what the 4 categories we had talked about before. The government cannot punish speech because someone might find it offensive. All right, Miller versus California, 1973. In order to be legally considered obscene and not free speech, speech must meet the following 3 criteria. Whether the average person applying contemporary community standards would find that the work, taken as a whole, appeals to the prurient interest. Prurient interest, I should say. So the question here is it overall excessively, unwholesomely lewd? That's still vague, folks. That's still vague to me. By what standard do you determine that? How do you determine, as a Christian, I got a standard, it's called the Bible, that I determine it. But legally, as far as our national law goes, how do we, legally, how do you make that determination? Whether the work depicts or describes a patently offensive way sexual conduct specifically defined by the applicable state law. In other words, is it obviously offensively vulgar? Once again, vague. Where's the stopping line of vulgar? What's the dividing line? Obviously, there's nothing on a pride parade where people are walking down the street pretty much naked in a pride parade. That has never, I don't know of any cases where that has been considered to be offensively vulgar. So where's the line on that? Whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. In other words, does it have no other message, meaning, or use in our society? Obviously, you could say, well, a pride parade has a message and a meaning in our society, so that one would not apply to that. But at what point is it considered vulgar, and by what standard, and who determines the standard? That's something that always comes up in these cases. Courts must decide obscenity cases on a case-by-case basis using this criteria. That's pretty vague criteria, and so courts have a lot of latitude here. All right. National Socialist Party of America versus Village of Skokie, 1977. Speech that may be considered hateful is still protected free speech. Now, a lot of you will be happy to hear that one. The court did not define hate speech, however, and so we still don't have a definition of hate speech. Legislators try to come up with definitions, but it's never been tested in the courts. There is no hate speech category in U.S. law as of at this time. There's not a category. But the law did say that offensive, even hateful speech is protected unless it falls within one of the specific, otherwise defined types like true threats, like if I'm using offensive speech with the specific intent of bringing threat onto someone else, that's a different matter. The case involved a protest in a public park by a white supremacist group. Now that one has stirred people up. People get really, really, really mad and angry at white supremacist groups, and I can, so people get really emotional and really mad, and they want to just go after them. So this case came out of that. In a 2011 case, the Supreme Court restated the idea that even hateful speech can be protected when it is upheld when it upheld the First Amendment right of the Westboro Baptist Church to protest near military members' funerals with signs the military families found hateful. I remember the Westboro Baptist Church. There was a City College, San Diego, right down Park Avenue. There was a large contingency of students protesting on this side of the street. I was in the line in front of the students. And on the other side of the street were members of the Westboro Baptist Church. And I don't remember what their statement was that they were trying to make. It was offensive. Oh, I think it was an LGBTQ thing. That's what it was. They were making statements against the gay rights. That's what it was. And on the other side were police protecting that side of the street. So I remember them well. A lot of people really did not like them, and they were very offensive. I remember at one point they were being very offensive to people at a military funeral. Family members had lost their family member who was killed in battle, and they were having a funeral, and they, I guess this is when they were going to the grave site. I can't remember at what point, but anyway, Westboro Baptist Church showed up, and they were very offensive toward these family members. Your son should have never been fighting in the war, and all this kind of stuff, and just very, very hurtful. But hurtful speech is not limited. I mean, speech can be hurtful and still be free. They still fall under the free speech statute. All right, Texas versus Johnson. Hey, you Texans out there, 1989. This one's going to get a lot of hatred. Flag burning is protected free speech. And this is a case out of Texas. A Texas law against flag desecration violated freedom of speech. The Supreme Court ruled there can be some limits on flag burning, such as for fire safety, but it cannot limit simply because someone disagrees with it. If burning the flag is deemed by the fire marshal or someone like that at that particular location to be a fire hazard, then yeah, you can restrict it. But just because you don't like them burning the flag, the Supreme Court in Texas versus Johnson has said you got to let them do what they're doing because it's protected free speech. I've seen recent videos of people burning gay pride flags. So remember, it goes both ways. I wonder how long it's going to be before somebody gets a sickle and hammer communist flag and burns it on camera and puts it on social media. It goes both ways, folks. All right. Citizens United versus FEC, that's a 2010 case. Corporations' money independently spent on political campaigns is free speech. Ooh, a lot of people are going to hate that one too. You don't always have to agree with the Supreme Court, but anyway, this is what they said. Basically, political spending is free speech. Laws that put limits on how much corporations could spend on political ads violate the First Amendment, so they can spend as much as they want on political ads. By the way, under legal terms, a corporation is a person. So, all of this big corporation influence in elections is protected according to the Supreme Court. But that also includes labor unions. They can spend as much as they want on elections as well. So we can discuss that one on how that affects our elections, and it does affect them to some degree. But there's a pushback that's happening now. Corporations are learning the hard way that, you know what, us little people out here, we also have a voice. And our voice is much more powerful than they ever thought would ever occur. Just ask Bud Light and other corporations. Ask Disney how their finances are doing after they have insulted millions of their customers. All right, Reno versus ACLU, 1997. Free speech is protected on the internet. Yes, now don't get too excited about this one too quick. That doesn't mean that the censorship that's going on on social media platforms is covered in this decision. It's not. Sorry. But I'll give you the decision anyway. This is based upon a law passed by Congress called the Communications Decency Act, which restricted, turn the page. These pages tend to stick together and then you can't turn them. The law restricted some types of content online in the interest of protecting children. But the problem is the court found that it was also restricting adults in seeing the content. That's where the problem lay. The court declared that the law to be unconstitutional and that the internet is deserving of full First Amendment protection. Now, this is where the other part comes in, where I said don't get too excited. The decision did not restrict websites and media companies from creating their own policies for content. They can create their own policy for content. There has not been a court case that has told them that they cannot do that. So the question still lies where it has not been answered. Are they a publisher or are they just a platform for people to have free speech? If they're a publisher, they can restrict people's speech. If they're not a publisher, then they're not allowed to restrict people's speech on the platform. So so the question is, when they set their own policies for content, do they become a publisher? The courts haven't really decided that one yet. All right. United States versus Alvarez. I'm thinking I need to go back to this other one. There's something I might have been missed that I needed to tell you guys. I think that was it, what I was talking about. Don't think that you can go after them for censorship if they're setting their own policies for content. If they can do that, then that means they can kick you off for whatever reason they decide until a court comes along and says you can't do that, unfortunately. All right, United States versus Alvarez. That's a 2012 case. Get this one. Lying is sometimes protected free speech. Unless you're lying under oath. Don't lie under oath. That's called perjury. This is a case involving the Stolen Valor Act. Now, I know I'm a veteran. A lot of veterans out there, we don't like stolen valor at all. It dishonors us. It dishonors the hard work that we put in. I have medals in a display case over here from my military days. I have ribbons. I have awards that I, through blood, sweat, and tears, earned. And then someone else comes along and they just flippantly put on a uniform and put on medals when they never earned them, or claim they had something when they never had it. Um, that's a insult to us. That just spits in our face. But it's protected free speech, folks. United States versus Alvarez. A California man falsely claimed to be a Medal of Valor winner or a Medal of Honor winner. Man, the Medal of Honor is the most coveted award in the military. And it's almost impossible to get that award. But there have been quite a few Medal of Honor winners because they met that standard. Anyway, the court ruled that this was free speech. The court ruled that there was no exception to the First Amendment for lies. However, it's illegal to lie about military service to receive financial benefits. If they went to the VA, having never served in the military, and falsely presented themselves as a veteran, they could be prosecuted for that. All right, next case. Mahanoy Area School District versus BI. That's a 2021 case. Students' off-campus social media posts may be protected free speech. So this is an important one for parents and students to pay attention to. A student was punished for a curse-filled social media post about the school and cheerleading team. Who gets mad at a cheerleading team? Well, I'll tell you who. Which she posted off campus. So there's your answer. Because it was free speech and didn't interfere with school. This decision was based on the standards set in the 1969 Tinker case. Remember the 3 students that had the black armbands, that case, which said that schools can only limit disruptive student speech. If it disrupts the function of the school, like I said before in the college case, if it's disrupting the classroom and so forth, then yeah, they can deal with that situation. So, off-campus posts and social media and so forth, the school can't hold that against a student. Here's the last one, 2023 case, very recent. 303 Creative LLC versus Ellinus. If you're a Christian business owner, this case is very, very important for you. And here's what the case said. Business owners may not be required to speak in violation of their beliefs. Owners of businesses that produce speech or creative messages cannot be required to produce messages for customers with which the owners disagree. This is 303 Creative LLC versus Ellinus. It's Elenis if you want to look it up. 2023 case. Now, the Supreme Court ruled in June of 2023 that a website designer could not be required to create websites celebrating the weddings of same-sex couples because the First Amendment protects the right not to speak. So this would also extend to like bakeries where they walk in and say, we want a cake, we want somebody performing a sex act on the cake and LGBTQ written on it for our wedding and all this. And the business owner is a Christian, they're saying, I can't do that. That would violate my religious beliefs. That would put me in bad stead with my Lord. I can't do that. This case, 303 Creative LLC versus Ellinus, it's Elenis, in 2023 says that business owner is not required to make that cake. So that settled that one once and for all. So there's your free speech cases. It's called case law. When the court decides something on a constitutional matter, that's what is termed as case law. They made law based upon their interpretation of the Constitution. So that's case law concerning free speech rights. So now you know your rights a little bit better. Let me turn this off now. You know your rights a little bit better than you did before. God bless. I'll see you next time on the C-Files.